We previously covered the trademark lawsuit brought by Lost International, a surf and lifestyle brand, against Lady Gaga in connection with her Mayhem tour and its launch at the 2025 Coachella Music Festival. Lost had filed a motion for preliminary injunction, and in early December of 2025, the court ruled on that motion, denying Lost's request. I'm Scott Hervey, a partner at the law firm of Weintraub Tobin, and I'm joined today by my partner, Tara Sattler. We are going to talk about this court's ruling, a very interesting ruling, on today's episode of The Briefing. Tara, welcome back to The Briefing. I didn't think this James Katchmar did this episode with me the first time when we talked about the case. All right, why don't we talk about the basics? Since you didn't cover the initial case with me. So, all right, according to the complaint, Lost International is a California company that was established in 1985. It's a surf and lifestyle brand. Lost claims to have been using the mark Mayhem since 1988, so for a really long time, in connection with surfboards, surf equipment, accessories, surf videos, and clothing. Lost owns a registered trademark for Mayhem in the United States, and that trademark was issued in 2015, and it covers various clothing items like beanies, caps, jackets, pants, shorts, t-shirts, and tank tops. This particular trademark registration is for a word mark, which means that it covers the word Mayhem without having any particular font, style, or color requirements.
So the complaint here alleges that Lady Gaga released a music album named Mayhem on March 7th, 2025, and announced a worldwide concert tour under the same name. Furthermore, Lost claims that prior to the album release, Lady Gaga and associated parties began selling t-shirts and other clothing items with the Mayhem mark prominently displayed, allegedly with a nearly identical design to Lost's own products.
So Lost filed its motion for preliminary injunction seeking a preliminary relief enjoining Lady Gaga from marketing and selling clothing and headwear that bear the infringing Mayhem mark that are likely to cause and have already caused consumer confusion. In order to be granted a preliminary injunction, Lost would have to establish that they are likely to succeed on the merits and that they are likely to suffer irreparable harm in the absence of a injunction, and that the balance of equities tip in disfavor, and that an injunction really is in the public interest.
So when you previously analyzed the strength of Lost's trademark claims, you did so under the framework of the Sleekcraft factors, the multi-part analysis courts use to determine likelihood of confusion in trademark cases.
Right. We did that because the crux of Lost's motion addressed Gaga's use of Mayhem on clothing and not really in connection with her tour or her album.
But the district court actually took a different approach. The district court applied the Rogers test. And as a reminder, under Ninth Circuit law, when a trademark is used in an expressive work, the court applies the Rogers versus Grimaldi test rather than the traditional Sleekcraft likelihood of confusion analysis.
Right. Although Lost conceded that Gaga's music album is an expressive work, Lost argued that the Rogers test should not apply because Gaga's use of Mayhem on clothing and headwear is not merely expressive, but serves as a source identifier, which misleads consumers into associating Lost brand with Lady Gaga. Their argument was essentially fine. You can call the album Mayhem, but when you put that word on t-shirts and hoodies, you're no longer being expressive or using it in an expressive manner. You're using it as a source identifier. However, the court found the plaintiff's argument, Lost's argument, unpersuasive. Based on Jack Daniel's properties versus VIP products and a number of cases following Jack Daniel's, this was a big surprise. And it raises the question as to whether the anti-Rogers pendulum is possibly swinging back towards the middle.
Yeah, so let's get into the court's order and discuss why it found the Rogers test applicable.
Sure. So the court looked at Ninth Circuit precedent, particularly the case 20th Century Fox versus Empire Distribution, that addressed situations where promotional merchandise was tied to an expressive work. In that case, the Ninth Circuit said that, quote, it requires only a minor logical extension of the reasoning of Rogers to hold that works protected under its test may be advertised and marketed by name, close quote.
Right. In that case, the court said that the balance of First Amendment interests struck in Rogers and in Mattel could be destabilized if the titles of expressive works were protected but could not be used to promote those works. And as such, the Ninth Circuit in that case held that the Rogers test applies, not only to the title or body of an expressive work, but also to auxiliary revenue generating promotional activities, including the sale or licensing of consumer goods.
Right. So, based on 20th Century Fox versus Empire Distribution, the court in this case expressly rejected Lost's attempt to disaggregate the album title from the tour merchandise and expressly reiterated that the Rogers test is applicable to the revenue generating sale of promotional consumer goods and merchandise.
So, finding the Rogers test applicable, the court then applied the two-pronged framework of Rogers. The first prong is the analysis of the artistic relevance of the use of the mark.
Right. Under Rogers, the bar for artistic relevance is low, basically just above zero, and it satisfies. Here, the court found it easily satisfied. The album is titled Mayhem. The tour is titled The Mayhem Ball. Merchandise bearing that title plainly relates to the expressive work. Lost really didn't even ask the court to enjoin the album itself, which is all but conceding this prong.
Yeah, and the second prong is the use explicitly misleading. To satisfy the second Rogers prong, the plaintiff must show an explicit indication, overt claim, or explicit misstatement that misleads consumers to the source or content.
Right. So Lost argued that because Lady Gaga's use of mayhem on a commercial item, namely clothing, explicitly misleads consumers as to the source of the content of the mark, and specifically her nationwide concert, this will cause the consuming public to see Lost's mark and associate it with Lady Gaga. That was their argument. The court said that the plaintiff's argument appears to, quote, conflate the second prong of the Rogers test with the general Sleekcraft likelihood of confusion test, which applies outside of the Rogers context of expressive works.
Moreover, the only evidence Lost presented to support its contention that Gaga is explicitly misleading consumers as to the source or content of the work is her use of the mark. The court noted that the use of the mark alone is not enough to satisfy this prong. So, having found Rogers applicable and the two prongs of Rogers supporting Gaga, the court found that Lost is not likely to succeed on its claims for trademark infringement and false designation of origin, and denied Lost's motion for a preliminary injunction.
So, okay, based on the Supreme Court Jack Daniels case and some of the cases that have followed Jack Daniels, like the Home Vest Discovery Ugliest Homes case that we discussed last week, this decision feels at odds with Jack Daniels, but I'm going to talk about why it really isn't. So, at first blush, this decision feels like it really should collide head on with the Supreme Court's ruling in Jack Daniels. After all, the Supreme Court told us quite clearly that when a defendant uses a trademark as a trademark, the Rogers test does not apply. And here, Lady Gaga is putting the word mayhem on clothing. That sounds an awful lot like trademark use, and it also sounds an awful lot like the use that we saw in Jack Daniels Properties versus VIP Products, putting Jack Daniels protected trade dress on a squeaky dog toy.
Exactly. And if you strip this case down to its surface facts, it's easy to say, wait a second, shirts, hoodies, and hats bearing the word mayhem Isn't that precisely the kind of source identifying use that Jack Daniels said takes the case out of Rogers?
That instinct is understandable, and I think that is the instinct that a lot of lower courts kind of fall victim to, right? Especially in light of some of the post Jack Daniels cases that involved expressive works. Let's look at Punch Bowl Inc. versus AJ Press. We did a previous episode on that case, so I'm not going to go into great detail on that case. We'll include a link to it, probably in the show notes. In that case, the lower court dismissed the trademark claims under Rogers, and the Ninth Circuit upheld the lower court's dismissal. However, in the weeks following the Ninth Circuit's opinion, the Supreme Court granted cert for Jack Daniels. The Ninth Circuit stayed its original decision to await the Supreme Court's decision, and then subsequent to the Supreme Court's holding in Jack Daniels, the Ninth Circuit vacated its original ruling and then held that the Rogers test does not apply to this case because AJ Press used Punchbowl to identify its news website. The Ninth Circuit said, to the extent that any previous cases held that Rogers applies when an expressive mark is used as a mark, and that the only threshold for applying Rogers was an attempt to apply the Lanham Act to an expressive work, those cases are incorrect and no longer good law.
So since AJ Press uses Punchbowl as a trademark, regardless of the fact that there is an expressive purpose for the use of Punchbowl and that its use is not expressly misleading, the Rogers test cannot be applied.
Right, that was what the court said. So this raises the question, did the district court get this wrong? Is 20th Century Fox versus Empire Distribution no longer good law? Under current Ninth Circuit precedent, it could be, but I don't think that it should be.
So what can we take from this case?
Okay. This is really tricky, and this is the whole issue with the what I talked about last week, the over application of Rogers. So it would be easy to say that this decision reinforces that promotional merchandising, when tied directly to expressive works, continues to enjoy First Amendment protection under Rogers. However, in light of Jack Daniels and the Punch Bowl case that applied Jack Daniels, I don't really think we can read this decision this way. However, I do think this approach, the analytical framework applied by this court, it is correct. I think that Jack Daniels has been overapplied, specifically to situations that are closer to the factual context of Rogers, the use of a mark in connection with the title of an expressive work. It's worth noting that the Supreme Court in Jack Daniels specifically called out facts under which the Rogers test was created, the use of a mark in connection with the title of an expressive work. Also, the Supreme Court, in announcing its limitations of the application of Rogers, noted that there may be a, quote, rare occasion where Rogers may be applicable to the use of a mark in connection with an expressive work that also functions as a source identifier, close quote. And it seems that lower courts may have forgotten that caveat, but it seems that this court did not. I do think that Rogers should be applied to situations where a mark is used as the title of an expressive work, even though that use could constitute trademark use, such as in the case of a television series or in the case of a music tour. And under those situations, 20th Century Fox versus Empire Distribution still makes sense.
Yeah, I definitely agree with you, Scott, because it is common for there to be merchandise, as the case with the Gaga tour, associated with a music album and a music tour or a television show or a movie. And so it wouldn't make sense to be able to use the title for a music album, tour, television show, but not on the associated merchandise.
Right. I hope that lost appeals, and I hope that we get some clarity, one way or the other, on where the Rogers test is. In the Ninth Circuit, well, because this is, I think this is in California. I believe it's in California. Uh, because if it's in California, it'll be resolved at the Ninth Circuit, and the Ninth Circuit will have an opportunity to revisit its ruling in Punchbowl and uh, determine whether or not um, this case is different than Punchbowl, and whether or not the district court in this case was correct and kind of, I think, correct the path that we're going down with the over application of Jack Daniels. Because otherwise, Rogers is going to apply to an incredibly narrow factual scenario, which is basically, the use of a mark as the title of a like single expressive work, so a film, a book, a album, and the use of the use of trademarked products within a television show or a motion picture. That will be the limited application of Rogers if the Ninth Circuit doesn't have an opportunity to revisit its decision in Punchbowl. We'll see. Hopefully, Lost will appeal.
Yeah, I hope so too. We will definitely keep an eye on it.
Well, thanks again to my co-host Tara for joining me today. Always great to have your insights. And thank you to our listeners for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review and let us know what topics you'd like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.